Hello, my name is Adrian Lifely. I'm a commercial disputes partner at Osborne Clarke in London. This video is in the series called Straight to the Point of Dispute Resolution, and today we're going to consider one of our specialist disputes areas, which is tax litigation. And to do that, I'm very pleased to welcome Ian Hyde, who's head of our tax disputes practice group. To help us get started, Ian, could you perhaps just set some of the background to tax disputes?
Yes, certainly. The tax disputes come from arguments with the revenue. So any taxpayer, whether an individual or a large corporate, having an argument with the revenue. Those arguments are coloured by, as you say, a lot of political and wider issues. Mm-hmm. So in most recent years, there have been a lot of press coverage about taxpayers not paying the right amount of tax. The revenue are under pressure to collect because of that. And also the revenue is in a very different position than a normal opponent. They can't do deals on tax, they have to enforce the tax regime that Parliament sets down. So that all of that creates a very different climate for tax than a civil litigation.
I get that. So how does that have a bearing on what tax litigation is like?
Well, it means the revenue tend to pursue litigation much more than you would in a high court context. They can't do deals. Everyone will remember sweetheart deals and the problems the revenue got into with that. So they have a code called the litigation and settlement strategy, which means that if they are more likely to win a case than lose it on their own advice, then they have to litigate it. So they can't just go into a smoke-filled room and come up with a deal. Very different.
That's interesting. So in the normal commercial disputes cases that I do, clients who are usually corporates, they are looking for a commercial settlement, and a claimant who may have a very good claim will very often settle for less than 100% of the claim for maybe reasons to do with the relationship with the counterparty or other considerations. Are you saying that that isn't the way that the HMRC behaves in tax disputes?
Well, in principle, no, they shouldn't. In principle, they should be looking at what is the right amount of tax to collect for that taxpayer. They're also influenced by the fact that if they take a policy line on a particular point, whether a particular item of expenditure is tax deductible or the VAT status of something, they have to do that across all taxpayers. So they have these policy lines that they have to keep to, that the legislation means X, and they can't change that, or they can't, without senior buy-in, change it for one taxpayer. So all these reasons mean the revenue are much more constrained than your commercial opponents. They can't just decide to give up for wider reasons. Now, that's in principle. I think in practice they do. But getting them to that position can be quite difficult. They have to look at all these other factors, and then you have to get them to move. And that can be, as I said, quite difficult.
So whereas the majority of commercial disputes settle, it sounds like it's a minority of tax disputes that do settle. So let's consider what the procedure is when there is no settlement and the case is contested. How does that work?
Well, you're going to a specialist tribunal called the tax tribunal, which was set up to hear cases staffed by dedicated tax judges. So it's intended to be less formal than the High Court, but as is often the case with these sorts of tribunals, it has become more formalised in recent years. There's much more emphasis placed on compliance with rules in the way that you'd be used to with the White Book. There are still oddities, though. I think the tribunal can be more informal. I think there's a range of cases that get heard, and they can be more informal for smaller cases. But it's also true to say that how a case progresses to the tax tribunal can be very different than the High Court experience. The revenue can take a long time. It's not unusual for cases to take a long time. And the legislation, the tax legislation, can impose very specific rules on things like burden of proof, which means that cases play out differently in the tax tribunal depending on the issue that you're focusing on the case.
And how about things like costs and the length of time it takes for a case to be heard. How do they compare?
Well, I think there's this range of cases. Again, I think at the top end, the sort of cases I tend to get involved in, it would look very similar to a High Court hearing for you. You have QCs, no wigs, but you have QCs, and you will have solicitors. You'll have the full range of an appeal and cases going on for weeks. So that's at the top end. But, as I said, the tribunal is intended to cover all tax disputes. So you will have much smaller cases, say an individual challenging a penalty for failure to file a tax return, that either he appears himself or with his accountant, and the case can be over with in an hour or two. So at that end, it looks very much more like the magistrates' courts, perhaps. Mm-hmm. So you have a full range in the tribunal.
And the costs, I suppose, depend on what kind of case we're talking about. But how does that square with what one hears, which is that the revenue is incredibly slow and difficult to deal with?
I think you've got different stages of the life of the tax dispute. I think once you're in tribunal, the tribunal is now much keener and will not put up with delay. That used to be the case that the tribunal would just allow whatever delay and would just let it drift. I think that's changed a lot in recent years, bringing in much more white book principles. However, the stages before you get to tribunal, there is still, it can be very frustrating for a taxpayer because the revenue operate by their own timetable and can often take months to reply to a letter, and you end up with cases dragging on before you get to the tribunal, and that can be quite difficult to manage. But there are ways to manage it, and that's sort of part of my job is to manage that sort of process, because clients will often want to get things moving, and particularly in any circumstance where you had to pay the tax, then clearly you want your day in court. So.
Great, well thanks for clarifying that. Just trying to pull all of this together, do you have any top tips for a corporate or an individual who maybe is facing a tax dispute with the revenue?
I think the big factor to bear in mind is the enemy is very different from a normal litigation opponent. They have these rules and pressures that they're under, that they cannot apparently do deals, that they have to collect the tax, they have to keep consistent approaches on different tax legislation. So you have to understand your enemy, essentially. That would be my first and main tip for you. Second one, if you do want to settle, and it is possible to settle with the revenue do ADR, it is possible to reach accommodations on the rights questions. If you're going to put a settlement proposal to the revenue, you have to do it in a way they are willing to settle on. So you have to work out how their litigation and settlement strategy will apply, what their policy pressures are, and then formulate your offer to take all those into account. I think that's really the way to settle. And finally, I think if you're going to litigate, I think you need to get on with it with the revenue. I think long letters, sometimes people like writing long letters, and the revenue will write you a long one back. I think sometimes long letters are a waste of time. I think if you're going to litigate, get on with it.
The long letters, as we hear more and more, don't get you anywhere. They just run up costs, maybe in further delay. Well, Ian Hyde, thank you very much for joining us on this video in the Straight to the Point of Dispute Resolution series. As always, please take advice on your specific situation before taking any decisions. Thank you.